Good day to all our viewers and welcome back to another What If session. My name is Veerpia and today's topic is what if an employee engages in unacceptable conduct outside working hours? Does the employer have jurisdiction to discipline the employee? We all know that an employer has the right to discipline or even dismiss employees for work-related misconduct. Now, in respect of this misconduct, we also know that the employer bears the onus of proof in dismissal disputes. Now, what must the employer prove? The employer must prove that the employee contravened the rule, that the employee was aware of or could reasonably have been aware of the rule, that the rule was valid, that there was consistency in the application of the rule, and finally, that the dismissal was the appropriate sanction. Now, an employer cannot necessarily dictate an employee's conduct outside working hours. The reason being is that employees' personal lives do not fall within the ambit of the working relationship. However, the distinction between the employee's private life and work life cannot always be separated, as the employer could have an interest when the employee's behavior affects certain aspects of the employee. For example, the behavior of the employee affects the employee's ability to do his or her work. It affects the good name and reputation of the employer or the employer's business dealings with others, or it affects the interpersonal relations in the workplace. In these cases, the employer may be entitled to take appropriate action against the employee. Now, should the employer wish to discipline the employee for conduct outside working hours, the employer bears the onus of proving that it has sufficient, one, and two, legitimate interest in the employee's conduct which justifies action being taken. So, ladies and gentlemen, not only must you prove that there's a rule in place, that the rule is known to the employee, that the employee contravened the rule, that the rule is valid, and that it's been consistently applied. If the conduct took place outside working hours, the employer is also required to prove that you have sufficient and legitimate interest in the employee's conduct, which would then justify action being taken. It is therefore important for employers to show that despite the conduct not being directly related to the employee's employment, it does impact on the employment relationship in one way or another. Now, examples of this can include that although not directly related to the employee's work, the conduct, for example, happened in a place or at a place over which the employer has jurisdiction. Examples being company pub or a hostel, for example. Another example is where the conduct happened during an off-site event organized by the employer, team building, weekends, year-end parties, etc. Third example is where the employer's reputation and or good name was adversely affected by the employee's conduct. The employee's conduct affected relationships at work. And finally, where the status and or seniority of the employee is such that his or her conduct outside working hours necessarily impacts on the employer. So, as I've mentioned, in addition to proving that the behavior constitutes misconduct, the employer must also show a link between the employee's misconduct and his or her employment. So the test is therefore whether the conduct was work-related or affected the employment relationship. We have seen many examples of this type of conduct outside working hours, but the most common examples we see these days are social media offenses. And in this regard, the question is whether employers can discipline employees when they post unfavorable comments regarding the employer or comments that may adversely impact on the employer on their own social media accounts, with their own data, with their own devices, and more importantly, the conduct or the posting of the unfavorable comment was or took place outside the workplace and outside working hours. Again, the question is, can you take action? The simple answer is yes. However, we still need to apply the test. Now, recently in Edcon Limited versus Cantor Mesa and others, the Labour Court, from a social media point of view, had to consider these issues. The court in this case confirmed that the fact that the misconduct complained of occurred away from the workplace and outside working hours does not necessarily preclude the employer from disciplining its employees. However, there must be a link between the conduct of the employee and the employer's business, similar to what we've discussed earlier. Now, the court went further and said that the test for determining whether there was such a link was or can be described as follows. At the end of the inquiry, what would have to be determined is if the employee's misconduct had the effect of destroying or seriously damaging the relationship of employer and employee between the parties. Now, if this can be established, ladies and gentlemen, even if it's a social media post, the employer may take disciplinary action against the employee, even if, as I've mentioned, it is a social media post. On that note, thank you again for watching or viewing this video. If you have any questions in this regard, please do not hesitate to contact us. Please go ahead and like our Facebook page. You are also welcome to post on our Facebook page any suggestions with regards to what if topics. We hope to see you soon, and keep an eye out for our next video. All the best, and thank you for watching. Bye bye.